series, David Lesch has addressed various topics that range from debit cards and credit card protection to consumer protection rights. Today, he discusses the range of consumer issues that take place in the Bronx Small Claims Court. And David, good to have you back.
Nice to see you.
We could be here all day talking about small claims.
Whenever we're talking about contract law, we seem to be focusing on the consumer protection statutes. And I know I'm taking a long time doing that. Eventually, we are going to hit some of the other contracts that people deal with in life, including prenups and other things. But there are so many different consumer protection statutes that I feel the Bronxites should know about, that's why we're focusing so much attention on it. And most of the statutes are referred to in Bronx Small Claims Court, where you can bring an action for up to $5,000. So let's talk a little bit about some of the statutes. The main one that I want everyone to think about is the General Business Law, Section 349 for deceptive business practices. Mm-hmm. Now, when people think of deceptive business practices, you're thinking of contracts where somebody purposely has you sign something when they know that it's really fraudulent and avoids the contract. Well, it does not have to be a purposeful event. In other words, if somebody mistakenly, it could be even an honest mistake, has you sign a contract that is considered to be deceptive, then it will still be voided. So just because somebody doesn't purposely have you enter into something that would consider to be deceptive doesn't necessarily mean it is, that it's still not a voided contract. It's whether a reasonable person would have thought that the provision or the contract meant something else. Let's talk about some of the things that come up in small claim court. We went through all the automobile issues a couple of weeks ago, repairs, new cars, used cars. We're not going to discuss that today. Let's talk about some of the other things that show up there. I'm an arbitrator in small claims court, so I see these things come up. Everything from asking for a particular wedding singer who may be 30 years old and they end up sending somebody who's 60 years old. That would be a deceptive, fraudulent contract that wouldn't apply. In vitro fertilization, guaranteeing a specific fertilization after so many tries, that would be deceptive. These are all things that are covered under the general business law. I'm trying to think some of the other ones.
Well, let me say this. How do you end up in small claims court? Is there a certain amount that makes a determination for small claims court?
It's up to $5,000. If it's above $5,000, you can go to Bronx Civil Court or any civil court throughout the city. You could sue for up to $25,000. But most of the disputes that the people have in the Bronx where they're not going to need an attorney are going to take place in Bronx Small Claims Court, and you have up to $5,000 a limit. They've cut back on the amount of days now that you can be present in Bronx Small Claims Court due to the budget cuts, but you still have Bronx Small Claims Court. It's still viable. It's packed, but you got to make sure that you pay your fee, you get your summons, you serve it on the defendant. But the issues that come up are generally covered by these consumer protection statutes, and most people don't know that. You have everything from furniture sales, guaranteeing that a furniture is going to be delivered on a particular day, but it's impossible for them to get you the furniture within a week. So the contract will automatically be voided. Au pair, guaranteeing that the au pair is going to be of a certain quality. You can't really guarantee that. You don't know exactly whether you're going to click with an au pair. That was an issue that's been litigated. These are all issues. Pyramid schemes. Most people don't realize that they're trying to get their money back from somebody because they've given money, but they've given money in what would be considered a Ponzi scheme. So no, it's an automatically a void contract. You won't be able to get your money back. These are issues. But it's not just the general business law. There's also the real property law. One issue is the warranty of habitability always comes up.
Right.
Landlord-tenant issues. That's not covered by the general business law. That's covered by the real property law. Did the landlord give you an apartment that is infested with bed bugs or mice or something else? Is the paint peeling, ceiling starting to crack? That's covered by the warranty of habitability. That's covered by the real property law. That's something that certainly should be looked at.
Let me ask about burden of proof. Obviously, going into small claims court, you have to show the burden of proof. The burden of proof is on you if you're making that case. What kind of things are needed to be documented so that way things can go forward?
Well, you're going to need a witness to show that whatever happened in terms of in the apartment is really true. You'll need to bring pictures, assuming it's a warranty of habitability. If it's an issue, just your basic contract issue involving, let's say, that wedding singer issue or the au pair, you got to bring the contract in. Got to make sure that you show the arbitrator or the judge that the contract is misleading, whether it's done purposely or not. You have to bring that in. Witnesses are always important. The witness might be there when you enter into the contract, into the negotiation. That's important. Here's another one. door-to-door sales. That's covered by the personal property law 425 to 431. You're very vulnerable when somebody comes to your apartment or to your door and they're trying to sell you something. So this statute gives you a cooling off period, enough time that you can void the contract. But the contract has to have language that's big enough for you to see it and specifically tell you you can void the contract within a certain amount of days.
Right.
That's covered by the personal property law. Most people don't know that. Telemarketing. People call you up and they harass you. That's covered by the general business law. So these are all statutes in New York that you're covered with. And when you come in in small claims court, you really should know the statute that you're referring to.
You referred to telemarketing. How does one fight against the telemarketing?
Well, if you get on a list, Albany has a list. You go to the website. New York State has a list that you can go on so that nobody calls you. If they call you more than a certain amount of time, even though you're on the list, you can get certain money back. I mean, there was a time there was $500. They may have extended it or increased the amount. But there are statutes that protect you. So here's another one: CPLR, Civil Practice Law and Rules. I deal with this statute all day long in my office for home improvement contractors. Section 3015. A contractor has to be licensed. If the contract is not licensed, the contract is void. It doesn't matter if they become licensed after the home improvement is finished. It doesn't matter. If at the time they contract with you, they are not licensed, the contract is void. No matter how great a work that they did, it doesn't really matter. And that's because we, for public policy purposes, want our contractors to be licensed. That's very important. Here's a federal statute that protects you in small claims court, the Truth in Lending Act. That's when somebody makes a representation. These banks make representations many times that, we're going to give you your money back if you lose your job, as long as if you use this particular credit card or you take a loan from us. Well, that's not truth in lending. No one's going to give you your wages back. It's false. It's false deceptive advertising. That's 15 USCA 1601. You don't need to know that, but it's a federal statute. Mm-hmm. Lost overcoat. Your overcoat's lost from a restaurant. That happens all the time. You can get up to $200 back. That's covered by the general business law. Again, a consumer protection statute that helps you. Cash refund policies. General business law, section 218A covers you for that. Whether or not, there's a sign that might say you can't, as long as there's a sign that says we won't accept refunds, we won't give you your money back, but you can buy something else in the store. You see that all the time. That's okay. Mm-hmm. But there has to be a sign that lets you know that when you buy something in the store, it says that. Again, covered by the consumer protection statute. So there are so many statutes that protect you. You have to know that if you're going to go into small claims court, you have to hang your hat on something. Now, yes, a lot of it's common sense.
Right.
Especially with the car issues. Bring a mechanic, don't bring a mechanic, different repair estimates. But with the other stuff, it's not so much common sense. You should be able to refer to a particular statute that protects you.
Before we break, parting advice?
Parting advice is if you're going to sign a contract, make sure that you review it with an attorney. That's always my advice. But if you don't have an attorney, you can't afford one, then just get somebody else to help look through the document, read the fine print. It's always the fine print. And if you don't know, ask. Before you sign something, ask. That they explain, what does this mean? Do I have a refund? Do I have a right within 3 or 4 days to cancel the contract? Don't be embarrassed, especially if they come knocking on your door.
All righty. David Lesch, as always, thanks a lot.
See you next week.